Welcome, and thank you for your interest in the ethics of aging clients, navigating in muddy waters. I'm Carolyn Rosenblatt, a registered nurse and an attorney with expertise in aging issues. I'm the co-founder with Dr. Davis of agingparents.com and aginginvestor.com.
Hi, I'm Dr. Mikol Davis. I'm a clinical psychologist. I have background in geriatrics and also in issues regarding competency and aging.
No matter what area of law you practice in, and no matter whether you've ever encountered elder abuse yourself, you're likely to meet age-related client problems sooner rather than later. Our population's living longer than ever before in history. Aging persons are at high risk, even if they're competent. We want you to understand diminished capacity, the nuances of decisional capacity and financial capacity in particular, and to understand more about elder abuse and confidentiality. So why is this a big deal? Well, diminished capacity in aging clients may not be so easy to spot. It tends to have a very insidious onset, and it's not readily apparent to someone who's not been trained or educated to spot the warning signs. We're going to help you with that today. Lawyers have minimal education about the changes of aging. After law school, you have to either seek supplemental education about aging and its effect on our clients, or we risk a lack of competence to address the challenges we'll eventually face with our oldest clients. The number of people aged 65 and over was at just 13% in 2010 and was 9.8% in 1970. It's much greater now. We're living longer these days. Why isn't this just an elder law issue, you may ask? Well, aging clients show up in every area of practice. Business, real estate, personal injury, criminal defense, tax, corporate law, and other areas are all affected. We've seen elders involved in each of these areas with lawyers representing them. Now, what are the ethical concerns? That's what this program is about. If you persuade an elder to do something, or you engage in any transaction with a person who is not competent for the decision you need, you can be accountable to those affected. Decision-making and diminished capacity are questions we all have to answer. All of our clients need to make decisions about what you're dealing with them over sooner or later. Sometimes they follow our advice, and sometimes they don't. With older clients, there's always a risk that decision-making can be impaired. This seems to be true of some of our other clients, doesn't it? But we're talking about age-related impairment here. We're obligated by our duty of loyalty to our clients to ensure that they have the ability to understand what we're attempting to do for them as best we can. Now, there's a lot of confusion about capacity for making decisions. Some people think if a person has testamentary capacity, they're fine, or if they could understand a simple contract, they're fine. But the more complex the decision, the more capacity a client has to have. Now, for example, a client may be fine to enter into a contract that says, I will paint your house for a certain sum of money. That's simple enough. The amount of analysis required is pretty low. On the other hand, how about the merger and acquisition of a business your client owns? If your client is cognitively impaired, will she be able to understand the deal, and if it's right for her, or if it's in her best interests? Perhaps not. The range of capacity required for any legal matter is tied to how complicated the matter is and how much your client needs to understand about it to make a reasonable decision. A lawyer should not assume that a 95-year-old will easily grasp the complexity of a transaction just because he's experienced, or just because he used to be sharp, or for any other reason. You need to look for signs of any problem before you proceed so that you feel confident that your client does have capacity to make the needed decisions, or that the client trusts you totally to protect his interests even if he doesn't have full capacity. That is an ethical responsibility. The age of your client has to be a consideration. Now, you want to ask yourself, are there any indications of difficulty in understanding, hearing, or grasping what you're saying? Are there any hints of memory problems, such as repeating oneself or asking the same question over and over again? Is anyone with your client, even with your client's permission, who appears to be pushing your client, answering for her, or telling her what to say? No one thing I just mentioned by itself is conclusive of diminished capacity, but if several of these things are there at once, you may have a problem. You need to not just plunge into doing the work. Take some time and meet with the client on a different day. See if you see the same things again. If so, exercise caution. You don't want to help anyone harm your client, and you don't want your client who doesn't understand something to harm himself. Now, what about capacity? What kind of capacity does your client have? You'll need to drill down into this area to be sure. It's not safe to assume that every client has capacity for financial decisions when the client is of advanced age, or just because the client still has testamentary capacity. The older the client, the greater risk of impairment. Financial transactions are particularly tricky. Most of us are not aware that financial capacity is the first skill to become impaired when a client begins to develop dementia. I want to repeat that. That is the first skill to become impaired. Everything may seem fine, everything else, but there's a lot that could be hidden from your view. Financial capacity is really complicated. Every lawyer should know what a client needs to have competency to enter into any financial transaction. Filing a lawsuit or settling one is, of course, a financial transaction. Entering into a contract with a lawyer requires one kind of capacity, and as the work is underway, other kinds of capacity may be required. There are actually 9 separate areas or domains that comprise diminished capacity. And Mikol, why don't you go through and explain these from your psychologist's point of view about what the research shows us about these 9 domains?
Well, the first domain is a very basic domain, and that involves money skills. And obviously that is all about the ability to identify coins, currency, the relative worth of what coins or currency have, and to be able to accurately be able to count money, understand that as a basic concept. The second domain involves financial conceptual knowledge. And what you will see as we go up the scale from the 1st to the 9th, they're more and more sophisticated in terms of these skills. The second one, which is a conceptual knowledge, is really more of a broader understanding. Does your client understand the components of a contract? Do they know what a loan is or an equity loan? Just even understanding the concept of a loan, understanding what that's all about. A warning here, older clients may process information more slowly than younger people. They're able to be accurate in their understanding, but often it takes a bit longer. So domain number 3 is cash transactions. This is obviously understanding what the price of something is, how much they would then need to be able to pay, being able to accurately understand if they were charged properly, what an increase in a price versus a rent reduction or a cost reduction. All of that is involved in basic cash transactions. The 4th domain is checkbook management. Does your client understand how to be able to use a checkbook register? Do they use online banking in lieu of paper checks? Do they understand charges against their account by the bank? Does your client rely on family to do the check reporting? The 5th domain is bank statement management. Can your client identify all of the components of what makes up a bank statement? Understanding the balance, being able to reconcile, being able to identify the differences between deposits and withdrawals. The 6th domain involves the financial judgment, and this is a more overarching area, and this is, as Carolyn said, one of the first areas that starts to clearly erode when someone has dementia or Alzheimer's disease. Does the person understand if they're getting paid, whether or not they've been paid properly or whether there's an error? Can they see scams coming at them? This is an area where they are often having greater difficulty being able to discriminate when someone is trying to manipulate and control them to be able to get their money. And this is where the brain no longer has the ability to tell that a person who normally you would see as being somewhat shady or fishy, is clearly someone that they need to steer away from. This is clearly where the judgment starts to fail in this domain. Bill payment is another area where we start seeing clients having difficulty where they're managing paying their taxes, or they're not opening their mail, or not dealing with their bills at all, and mistakes start happening and piling up. And this is truly where families, when they start to come visit, they start noticing that there's some problems, specifically in terms of the elder's memory about paying bills, taxes, etc. And this is something that starts to be far more obvious. The eighth domain, and we're almost at the last domain, which is general knowledge of one's personal assets and estate. Here, this is obviously a far more sophisticated part of one's ability to use one's reasoning when it comes to finances. This is where a client would understand their annual income, understand where their income comes from, and clearly being able to know when it comes to dealing with one's personal financial statement, what all it would be involved in a financial statement, understanding the difference between assets and the debts that they have, and understanding that one's personal assets and or estate is the sum total of both the assets that they have and the costs.
And let's illustrate that with a case that we dealt with. This was an older woman who had a daughter who thought that she was probably being taken advantage of by a charitable institution. And I asked her, do you know how much money you have? Because I was trying to test out whether she had knowledge of her personal assets and estate. And her answer was, there is no possibility that I could ever run out of money, none whatever. And she really believed it. Well, of course, her daughter told me that was certainly not true. This person was being taken advantage of by a charity. She didn't understand her total assets. She did not have financial capacity.
And here's the last domain. Obviously, when it comes to being able to make investments and understanding the nuances that are involved in making nuances, this is where one can decipher where one is giving money as a loan or one is giving one money as a gift. And as Carolyn was saying in the prior example, this individual truly believed that they had unlimited amounts of funds, and so the fact that the church encouraged them to give to a building fund that they had, and she donated over $100,000 to the church, she clearly didn't understand that actually her net asset, I think Carolyn at that time, her net asset was maybe a grand total of maybe $200,000.
It was something close to that, but basically she would have bankrupted herself if she'd kept this up.
And she was in her 80s or late 80s,
Mm-hmm.
right? Okay.
So basically, what are you supposed to do to determine whether somebody has financial capacity? Now, a lot of lawyers make a mistake here, and this is where we want to emphasize your ethical obligation. I've heard this directly, and there are cases that I could go on for a long time about where the lawyer thought the client was fine because they could carry on a nice conversation. Is that enough? It's not. A person can be totally capable of discussing current events, the latest sports activities, politics, anything, but at the same time be impaired for financial decisions of all kinds. Remember, we were saying that the financial decision-making capacity erodes first. So when someone is developing dementia or diminished capacity overall, all the other kinds of abilities that they have might look just fine. Now, sometimes the client is allowing other people to access their money, but they are carrying on their lives as if they're fine. In one case, a father seemed fine when you talked to him, but he had allowed 2 convicted felons to move into his home. He thought they were his friends. They got money from him every month, and it was reported to me by one of the relatives that these felons ran a drug operation out of his house. So the son, who was the client, had tried to evict the tenants because the son owned the house. And the father, who I believe probably did have dementia, consulted a lawyer who took the elder to the bank and revoked the permission the elder had previously given to his son, allowing access to at least see what was going on in the account, not to manipulate the account, but to just watch. And when asked if the lawyer thought the dad was capable of exercising good judgment, the lawyer said, "Yes, I wasn't finishing his sentences for him." Now, is that how you would determine whether a client has financial capacity? No, I hope not. So what if your client seems to be impaired, sort of? Are you supposed to do something? Don't take chances when you have reasons to doubt a client's capacity for your matter that you're handling. If a client is not competent in all those 9 areas that Mikol just reviewed with you, you may need to involve somebody else. Are there any rules you should follow? Does the bar tell us? Do we have anything particular that spells this out for us? We don't have clear direction. That's why we call this muddy waters. You have an ethical obligation, but I think it should be considered part of our duty of loyalty to the client. You want what's best for them and what best protects them from any vulnerability that you see. The point is, ethically, you need to look for vulnerability in the older client. We know it exists in at least a third of people age 85 and up, because we know that the risk of Alzheimer's disease doubles approximately every 5 years after age 65, and about a third of the people 85 and up have Alzheimer's disease or some related dementia. So the bottom line here is you need to be on the alert. Capacity is just not clear-cut, and that's a problem. So what do we do? What do we do? Let's say we've got doubts about the client. Let's say we've seen a few red flags, or we believe the client really isn't competent about making financial decisions, and we've got a complicated case we've got to handle for that client. When you're in doubt about capacity, you want to consider appointing an agent, durable power of attorney, a guardian ad litem, or somebody else to assist. You want to ask the client if they have someone that they can trust. The bottom line for you, it's the consequences of decisions that have to be in your mind. It can be anything from selling a business or a home to making other kinds of agreements. If there are 2 choices available in any legal transaction, and one of them can harm your client, and your client has cognitive impairment, that client may not be able to process the information about the outcome of a bad decision. It would not be ethically proper to allow your impaired client to make a bad choice knowing that it can harm him. And the operative word here is impaired. Yes, clients make stupid decisions. We've all experienced that. They don't settle that case when they should. They take the wrong price. They take the wrong place. They make the wrong decision. We advise against it. There's no law against making stupid decisions. We know this. But what's different about the impaired client is that they don't really have the judgment to say, yes, I know you're telling me this, and it's my decision, and I understand that I'm taking this risk, and I know what the consequences are, you see? Clients who are not impaired are different from clients who are impaired. If you've got some idea that the person may not understand everything you're saying when it comes to that fork in the road and that decision point, you have to put your action in a different light. You don't want to subject yourself to a malpractice claim later by heirs or others who are adversely affected by the choice the client makes when you suspected that that client was impaired. You may have to proceed with a surrogate decision maker. You may need to withdraw. There are certain choices you can make. But if you don't explore this, you are really setting yourself up for trouble. So, what are the things that you need to ask yourself? When you've got this deliberation going on within, my client's 80 and he wants to do this thing and he hired me and I've known him for years, but now he's different. You got to ask yourself whether you're convinced that this aging person does have financial capacity. Don't gloss this over just because you've had a relationship with a client, or you've known them for a long time, or they used to be a professor, or they have a doctorate, or whatever the reasons are. You've got to consider age as a tipping point for their capacity. And you've got to ask yourself whether you need to involve a surrogate decision maker to keep that client safe. Remember, you're looking for hints of memory problems, asking the same question over and over again, somebody coming in with your client who seems to be pushing them. That's kind of where it is when you do your analysis. If you see these same things occurring more than once, use caution. Consider the surrogate decision maker as a possibility. So let's illustrate this. We've got a case. This is Marta and her daughter Jenny. Jenny had been trying to get her mother to stop making donations and selling things. Marta wanted to be in a place where she could count on financial support, and she was convinced that the state would pay for her care if she didn't have anything in the bank. Now, I explained the concept of public benefits and Medicaid, we call that Medi-Cal in California, and how limited a benefit this is, and that it could mean being forced to live in a nursing home, which she definitely did not want to do. This is an elder who's physically impaired. She's got it in her head with this crazy idea that all she has to do is empty her bank account and somehow, magically, she's going to be well taken care of. So I set out to try to gently explain what the truth is, and she listened and she nodded and she asked a few questions. Her daughter had been through this with her before. Her daughter again explained what I had just said, and Marta's response was, "I want to give away all my money so the state will take care of me." Marta, the impaired elder, was not able to understand or process the facts. She wasn't able to get the concept of the limitations of the decision of getting rid of all of her money. Her belief was not true. It would have led to a very bad outcome, to completely impoverish herself with nothing in the bank. And that would be a terrible result. If you just did what she said, you say, okay, give away all your money. But that wouldn't have been the right thing. Now, if Marta came to you and said she wanted you to help her with a transaction to dispose of her assets, what would you do? And Marta did, in fact, have dementia. It had not been diagnosed at the point she saw me, but it was later diagnosed. Now, if a Marta comes to your office, do you consider whether you should always do what the client wants? Remember that this diminished capacity problem is very subtle at first. It gradually gets worse, but you've got to understand those red flags. You've got to ask yourself whether you really get the red flags of diminished capacity. Because you can counsel a client to do something, such as sell or not sell a business, or accept a settlement, or enter into a contract. And if they don't listen to your advice, do you go ahead if they insist? Or do you consider whether your 85-year-old client might not be following your direction because of impaired judgment? Doing everything the client wants is not always the rule that we have to follow. It's true with younger people who seem to be competent. It's not always the rule to follow with older people who may not be competent. So what do? Well, you have to assess their capacity. You've got to make a reasoned decision before you do anything with that client, even if they pay us and tell you that they want you to do what they want. If you've got doubts, you've got to figure whether it's better, safer for the client, and more ethical on your part to withdraw and not do as an impaired client wants. So in your analysis about capacity, you have to consider these three components. There are the red flags that we mentioned, which are the problems with memory and repeating oneself and asking the same questions over and over again and so on. But your analysis, and we're all analytical as lawyers, aren't we, should be or can be broken out into three parts. You want to figure out their reasoning ability, you want to figure out their appreciation of consequences, and very importantly, you want to figure out their consistency with previously expressed values or historically held values, like a conservative person suddenly wanting to do something very rash. That would be inconsistency with previous values. So let's get into the concept of reasoning. You're not going to know what your client thinks unless he or she is able to tell you. So reasoning also includes the ability to articulate what's in the client's mind. Now, people with cognitive decline caused by Alzheimer's or other kinds of dementia lose the capacity to use words they want to use. They have trouble finding words. They have trouble recalling words. They might say, if a woman says, that thing where I keep my money, instead of saying purse, or that thing I put on my foot instead of saying shoe. If the client's doing that more than once, these are clues, but they may be important clues to their diminishing ability to reason and think clearly. Dementia can cause this. Other kinds of cognitive problems may be responsible, but the end result is the person can't clearly reason and can't clearly express what they think. And again, along with those domains that we talked about, those 9 areas of financial capacity, understanding the consequences is part of your analysis of your client. Can your client appreciate the consequences of a decision? People who are impaired with dementia lose the ability to see the whole picture, and that includes long-term results. One of the characteristics of some people with diminished capacity is impulsivity. They jump into things, they don't think about it, they want to go right now, they want to sign the paper right now, they can't wait, they don't want to think about it. If they can't appreciate what the consequences of a decision look like down the road, and that it may not be in their best interest, that needs to be a consideration for you. You are responsible to help them with that if you've got these concerns in your analysis. Do they need help in making the decision? That's the question. And this consistency with long-term values piece is very important, especially if you do not know the client well. If you don't understand historically that they've been very solid, they've been very measured, and now they're impulsive, or you don't understand that they have been very kind of inconsistent with giving money or not giving money, and all of a sudden they want to give lots of money away, these are the kinds of things that demonstrate inconsistency. It's being out of character. And you've got to know what character looks like to tell if somebody's out of character. A departure from long-term, long-held values and beliefs is a clue to diminished capacity. If somebody starts making dangerous choices, that may well be a client with impairment. If the client is known to you, that's easier because you've got the history. If it's a new client, you need to get input from somebody else, family, trusted others, with permission, of course, about a questionable or potentially dangerous decision your client wants to make, or a direction they're giving you that just doesn't seem right. If a client has always had a trusting relationship with an adult child and suddenly turns against the child and is manipulated into thinking that that adult child is after his money, that is a clue. This is unfortunately a recurring problem that we see at agingparents.com. They're told that so-and-so is after their money, and it's not true, but sometimes someone is abusing them. It's a favorite trick of abusers who use it to get control over an elder's assets with a new power of attorney. And sometimes they go to a lawyer to get the lawyer to draft this power of attorney, and the lawyer unwittingly says, okay, if that's what you want, sure, just because the client says that's what he wants. And if they're making a nice conversation for 10 or 15 minutes, the lawyer says, okay, they're fine. I'm saying look deeper. I think we all have an ethical obligation to understand that a departure from long-term values is a clue for us in our analysis of a client's ability, and that we need to examine that to hold up our own ethical standards for our loyalty to a client and their values. Well, okay, you think the client may be a little inconsistent, maybe they're not sure. Why don't you just write them a letter, put everything in writing? Will that fix it? Will that protect you? Well, get this. People who have a hard time taking in and understanding information and reasoning, which are all typical of dementia and Alzheimer's disease, they're not going to suddenly get better at processing information because it's written down. There are plenty of people out there with dementia who have trouble reading, not because they can't see the letters on the paper, but they can't make sense of them. They'll still struggle, and you're not protected for doing something harmful just because you warned the client that his direction could be harmful to him. You need to do better than that if you want to take the ethical high road here and not just act like some robot who can't think about whether this client might be endangering himself. So we always want to look for the least restrictive alternative for the client. And many a lawyer has said, well, the only solution is to just get this person under guardianship. They can't make decisions anymore. Just, get a conservator, get a guardian, whatever your state has, okay? Well, sometimes informal permission for help by an agent on a power of attorney may be far better than guardianship or conservatorship. Far better because the client still has the right to make some decisions. I've heard it said that people under guardianship have fewer rights than a convicted felon, and depending on the law where you are, that may be true. So that would be the most restrictive alternative for an impaired client, and a less restrictive alternative is to allow the client some decision-making for things that cannot harm him or her, and that would be things like where to live or what kinds of things they want to do for entertainment or things that are not as impactful as giving away their assets or selling a home or allowing a predator to take over. You want to do all you can to figure out if the client can really know what's in his best interest. He may have an opinion, and you can listen to that, but if he can't reason and process what's in his own best interest, that's where an agent who has power of attorney can be far more helpful than allowing the client to go off unchecked into these dangerous areas. So we always want to allow the impaired client to say what he or she thinks, but also understand that they may not get it about what's best for them. And what's best for them isn't always clear. I'm not saying any of these things are easy. This is muddy waters for sure, but we want to aim for the highest that we can for the client. When we have ethical choices, we want to make sure to understand that when we've got serious doubts about capacity, let's say you know that your client does not meet what we've described as 9 domains of capacity for financial decisions. 9 domains. Maybe they look like they're missing 4. Okay, well, that's serious doubt, all right? That's serious doubt about their capacity to safely consider a financial decision. So we want to either get a surrogate to help with that decision-making, check it out, and of course you want to make sure that surrogate is someone trustworthy, who has the client's best interest at heart, not the drug-addicted sonny boy who wants to take the money and run. You can also ask a client to undergo testing, or you can withdraw. Now, Mikol, why don't you explain very briefly what we mean by testing?
Well, the testing that you're talking about is psychological testing, and it's testing to determine whether or not there, in fact, is some problems either in the client's memory, where we can use psychometric testing that will show and compare based on their age and compare that with their education as to where they fall in the bell-shaped curve, comparing themselves with other people that are similar age when it comes to, let's say, memory. But there are other aspects other than memory that have to do with other ways of being able to understand and perceiving the world around you. And there are psychological tests that help us understand whether or not there are things that are getting in the way of people's ability to perceive reality and to understand, as you were saying before, Carolyn, what are the consequences if I make certain choices. And this is an area that is quite obvious when you start testing people, that this is an area that starts to erode quite quickly, is that people are unable to see the next steps if they choose to go in one direction versus the other. But more importantly, the idea of using some kind of scientific test, a psychological test that's normed. It has been used repeatedly for many years and has been used in testimony in court proceedings that provide a clear objective measure of whether or not that person does have some kind of diminished capacity, is a way of helping validate what you may be seeing in those red flags that Carolyn was talking about before. And that is very, very helpful. That'll give you peace of mind, particularly if, in fact, the psychologist with the testing validates there is some concern about capacity, so that you will have a better sense with having the science behind you that you have a clearer idea of what you need to do to keep your clients safe.
Well, can you talk about what the testing is? Because I think a lot of lawyers are not familiar with psychological testing, or if they're familiar, they think it's this all-day ordeal where the person has to go through 10 hours of, grueling things, and, it's only when you have a guardianship proceeding that it has to be done. What exactly is involved in figuring out whether somebody, let's say, can make financial decisions? What would you do?
Well, classically, a neuropsychological evaluation, which may be something that you're aware of, is what Carolyn's talking about, which is a very extensive battery of lots of different kinds of tests. They involve memory tests. They involve intelligence tests. They involve naming of different objects. They involve speed tests that involve testing how fast does someone learn a new task. They involve a lot of different aspects, and they make up what's called a neuropsychological battery. But in the issues that we're talking about, in looking at capacity and looking at specifically financial capacity, does that person have financial capacity, or in some cases do they have clear testamentary capacity? In order to determine that by using any of the tests that I just mentioned, you can use lots shorter versions of these tests, so that in let's say 2 settings where you test someone over a couple of hours each setting, maybe for a total of 2 or 3 hours total, you can get a pretty good picture psychologically from that testing to be able to provide some kind of scientific validation that the person either has capacity or is on their way out.
Well, are they standardized? I mean, who standardizes these tests?
All of these tests are standard through the American Psychological Association, and they've been used for many, many years.
So psychologists all over the country would use the same tests, right?
There are many, many same tests that psychologists would use. For example, in the neuropsychological battery, often a part of that is intelligence testing, and everyone would use a very similar psychological test.
Okay, when you say they're normed, what does that mean?
It means that there are statistical numbers that are based on looking at sample sizes of, let's say, an 85-year-old person with a college education, and what I mean by normed is that then we would take that data based on those factors and take a look at a sample size and see, based on that sample size, what would be the average kind of response that someone would have, let's say, in being able to name, let's say, how many things you can find in a grocery store in 1 minute, which would be one of the naming tasks. Mm-hmm. There would be, for example, in another test, there would be a picture and a series of pictures, and people would have to discriminate which of these 3 pictures fit in, which is the ones that are like, which are different. So it shows some form of visual discrimination. But a lot of it is really testing both the articulation and the speed of which that they demonstrate those skills. And
people are being compared to people with the same kind of education and age that they are?
Correct. That's exactly what they do.
All right. And you do this for lawyers to help them get a fix on whether their client has decisional capacity or financial capacity, something like that?
Correct.
Okay. All right. Well, let's talk about some of the dangers, some of the risks we face with our impaired clients. We know that impaired people have a hard time with decisions. Diminished capacity for decision-making of any kind makes clients vulnerable to abuse. And let's focus on that for a little bit here. Financial abuse of elders should be on the radar of every lawyer. We want to consider every aging client to be a potential risk for abuse because it is a huge problem. And I think it's important for us as lawyers to consider what we can do in our posture of advising, educating, and counseling our clients to stop abuse if we see some of the warning signs. There are things we can do. And, we don't all have to be on a mission about this all the time, but I really think it should be in our consciousness from an ethical point of view, because some clients are vulnerable and abuse is common and it's seldom reported. Certainly there's a huge gap between the amount that is reported to the authorities, namely Adult Protective Services, and the amount of abuse that actually takes place. So how big of a problem is it? Well, the studies that the government still holds on to are old. They assess that $2.9 billion a year is stolen from elders in the United States alone. And by the way, elder abuse, financial abuse, is a worldwide problem. Population across the world in developed countries is living longer than ever before. The older people get, the more abuse there is everywhere. But there's a recent private sector study which was done by some very competent people, and they studied all kinds of abuse, which include things like, taking somebody's money on a monthly basis when they only signed up for one thing, and money stolen subtly from bank accounts with excess charges, that sort of thing. Their figure, $36 billion a year plus stolen from elders in this country. $36 billion is a big number. And that means if any of us have any older clients, some of them are being ripped off.
And who are the biggest abusers?
Family. Unfortunately, family. The second most common abusers out there are caregivers. These are paid or unpaid people who come into the elder's home and help themselves to not only cash but jewelry and other valuables. There are some horror stories out there where no one was paying attention and people have been financially decimated. But also understand that financial abuse can affect any elder, whether they're impaired or not. And do we have an ethical obligation in this regard? I think so, especially if we see warning signs.
And aren't financial and or professional people equally predators that are often involved in financial abuse?
Indeed they are. They're not equal in numbers to family members who steal and caregivers who steal. But unfortunately, because professionals, including unfortunately lawyers sometimes, but certainly financial advisors and accountants and other people who have access to the information about money, they steal the most money of anybody. We've all heard those horror stories and disbarments, but it's very sad, and I think we all need to be more conscious. So what are we looking for? Well, as we mentioned before, when there's somebody standing next to your client in your office or sitting down beside them telling them what to say, that may be a warning sign. The manipulative other might be perfectly well-intentioned, and sometimes when the elder's impaired, that is exactly who the surrogate decision maker needs to be. But it's a two-edged sword. Sometimes it's a manipulator. Sometimes it's a predator. Sometimes they're trying to get your client to do things that put them in a position where they can steal. So we need to look out for that. And again, a sudden change in habits. This goes along with that departure from long-held philosophy and beliefs. Investments, selling a home, giving away money are some examples. Doing something that would be considered rash in comparison with what the elder has done in the past. Another big warning is a romantic relationship with somebody who is a loser. They've got no money, they have a history of being in jail. Whatever it is, there are professional gigolos out there, men and women, who take advantage of older people, particularly after a spouse dies. If you have an older client who loses a spouse, I want you to consider that person vulnerable in everything they're doing. And you're the lawyer. Ask questions. Find out about what's going on in their lives. These signs that are here on this slide are some of the common signs that often accompany financial abuse or manipulation of an elder. The manipulative person could be a family member. This is a crime of opportunity. If your client has been happy in her home and can manage there, and all of a sudden she tells you she's selling it, that could be a warning sign, particularly if she's in a relationship of trust with someone who has convinced her to sell the home. This can be very dangerous. It might also be necessary. So again, you've got to look at the whole picture. Maybe the elder can't manage anymore. Maybe it's a widow and she just can't handle the household responsibilities and it's time for her to move to a sheltered environment like a care facility. But if you are involved in any aspect of this, I ask you to please look closely at all of the factors that might be influencing that kind of decision. There are lots of warning signs of elder abuse. Some of the other ones are isolation of the elder. That means nobody can reach her. Nobody can call him on the phone. He doesn't use email or he doesn't respond. An unexplained change in the will or trust for the benefit of somebody different, especially if that's someone who's never been involved in the elder's life before. That's a big red flag. Unusual spending, writing checks to people, caregivers, family members who say that they're just borrowing money for a little while. These are some of the other common warning signs. Now, you'd learn that your client was being isolated from others if you could not reach her. If you call, and somebody's always answering the phone for him or telling you that he's not available, that's a warning that you need to pay attention. Cutting elders off from contact with their trusted people is what abusers do to cover up their theft and their fraud. An unusual financial activity that you learn about is another warning sign. Big withdrawals from their banks, creating a new trust or will, disinheriting relatives. These are warning signs. There can be perfectly good reasons. People have the right to change their estate plans. They may be perfectly okay, but sometimes they are part of a pattern of abuse by a manipulator. We just want to raise your consciousness about that. Now, here's an example, and this comes from a true story that happened in the state of California. It's what we call the $4 million ripoff. There's an elder in her 70s. She develops a disabling physical illness. She had done very well with her investments. She had $4 million. She had some small shopping centers, retirement accounts. She had gotten multiple sclerosis and became eventually bedridden. So she hired a full-time caregiver on her own, and the caregiver apparently got a power of attorney from the client. It's not clear if this was done by fraud or if the elder gave it willingly at first, but the caregiver had a field day. First, she cut off contact with everybody. Now, this woman had to have a lawyer at some point if she's doing all these real estate transactions and had a will and a trust. She didn't have any children. She was single, and there were a few other relatives in another state. The caregiver and her son opened 62 accounts in 10 different banks and sold off all of the elder's real estate. This went on over a period of 6 years. The caregiver put her son through a private school. They bought themselves new BMWs. They were having a wonderful time, and the caregiver was gambling. This money disappeared, $4 million. So we're saying, where were the professionals in her life? If the client wanted to sell a shopping center, where were the professionals when she couldn't get into an office by herself? Now, if you were her lawyer and the caregiver contacted you with a request to do any legal work, would you be suspicious? Or would you just take the client's check and do whatever was requested? This is an ethical concern. You need to be watching any of those kind of suspicious-looking things. We're saying don't just let them pass. Maybe it's fine. If a person is disabled and can't come into the office, maybe you need to go to the client. If the client can't come to you and someone else is always answering the phone and won't let you speak with that person, maybe you need to find out why. Go there and knock on the door, dispatch somebody to look into this more thoroughly, ask to see a record of the bank account because you need that. Whatever it is, as an attorney, you have a certain degree of power to get information and to investigate. And I think it's our obligation for every aging client to use that power when it seems appropriate to do so. You can get the client's permission if the client trusts you, and that's a key point here. The client's trust in us as lawyers to protect their rights. I want us to assume that elder abuse is always a risk. We want to be aware of everyone's potential motives. We want to ask why a client wants a proposed transaction, whether we're doing it or not. We want to be aware of anyone who seems to have control over your client. In this case, the caregiver had total control. Family members may or may not have your client's best interests in mind. You've got to find out as much as you can about the family member who's taking over as the surrogate decision maker. Any lawyer creating a contract, facilitating a sale, advising an older client needs to dig deeper and look for the big picture of what's going on. Disposing of the large assets by a disabled elder should raise red flags for you if this is your client. Now, let's talk about reporting elder abuse. In looking into the research about this, you'll see that every state has different rules. There are a few states, and I applaud them, which require that lawyers report suspected elder abuse. The American Bar Association model rules kind of give us an option. They don't say it's wrong. They say that you may take protective action, but you're not required to take protective action. And in my state of California, there are no rules yet. So they say keep client information confidential, but there are new model rules being proposed that will change that, to be more like the ABA model rules, where you may report, but you're not obligated to report. Now, it's easy where you're required. I hope that becomes the law everywhere. But it's very problematic. And one of the reasons I keep my RN license is because I'm a mandated reporter with that. And I tell any clients who come for mediation or consultation that if there's unreported elder abuse, I have to report it. It's not always so clear, and we'll tell you about how in a minute. But one option you can add to your attorney-client contract is that the client will waive confidentiality about elder abuse if your state does not mandate reporting it, and you're currently prevented from reporting it, as far as you know, because of client confidentiality. Okay? So that's something to consider that will give you the client's permission in advance before you even know there might be elder abuse, just as a standard clause that says if you suspect that this client is subject to manipulation, undue influence, financial abuse, that you have their okay to report that to the appropriate authorities. And that will give you the all right that you need to proceed. All right, so let's talk about an actual illustration where this was a real problem for me as a matter of conscience. I had a client at 93. She became a client at her daughter's urging. Her brother had taken thousands of dollars from this client's account, Fran, without her permission. And he had always been someone she trusted. He was her only son. She loved him. He also wanted to get her house and sell it and require that she come and live with him in a different part of the state. Now, that had been the history. She wanted to eventually to live with him, but she found out what that was going to be like. He was going to be gone all day. He was going to drop her off for 9 hours at an elder center, and that didn't sound so good. So she wanted to withdraw her power of attorney from her son. Now, I said to her, look, I know, I said this face to face, your son has taken money from your account without permission. You know that that's illegal, and you know that you can stop this. And the way that you would stop it would be by reporting this to Adult Protective Services. And this 93-year-old who did not have complete financial capacity looked me in the eye and said, I don't want my son prosecuted. Okay. Now, Fran was what we call a willing victim. This is very common, and it's part of the reason that most cases of elder financial abuse are not reported to law enforcement. This was a problem for me, because she had said, don't do this. And I knew that if I did report it, that the Adult Protective Services would interview her and she would say it's fine. I did not report it. Now, this confidentiality and communication with third parties is somewhat of a dilemma. But here's the important thing. As I was discussing with the attorney-client fee agreement that you may be using, it doesn't take a high level of capacity to give you permission to talk with a third party. Is it okay if I talk with your sister about this? Yes. Could you sign this permission? Okay. It's not a clear ethical area about communication with third parties when you think there's something bad going on. But if there is something unclear about your state's authorization under the rules that you have to follow, then consider getting the client's permission. And if the client says okay, then you can get this waiver and get it written and talk to their appointed third party and let them know that you're suspecting something wrong, that nobody's looking out for your client's best interest in this or that situation, and maybe that someone else needs to step in and help with that decision making. If there's already an appointed agent on the power of attorney or healthcare directive, that's great. The red flag problem is that if the appointed third party is someone who might be the abuser, as in Fran's case, then you've got an obligation to do something else and to talk to another trusted person. And again, this has come up in mediation. We had a case where a couple of siblings were arguing over who should be the conservator for their dad. The dad wanted both of them to be in charge. The daughter and the son were in conflict. The daughter had already neglected the father and had been reported to Adult Protective Services. They came to mediation to try to work that out. We mediated that case. The daughter was supposed to provide food for the dad. It came to my attention from a caregiver that during the time this mediation was going on, that the daughter had not bought groceries once again, and it was a repeat of the same thing that had brought this matter to the attention of Adult Protective Services in the first place. Now, we had a problem. This is a confidential proceeding in mediation. We could have reported the allegation to Adult Protective Services, which would have been in violation of the confidentiality rules of the mediation. We might have not done anything and let it proceed. Well, ethically, sort of okay, I guess, if you can live with it, which I couldn't. We could have withdrawn from being mediators, or we could have tried to find another solution. And the other solution was the path we chose. I called a conference on the phone with all three counsel involved, told them of our impressions of the daughter, and asked them to reconsider having both the siblings serve as co-conservators. And they eventually worked it out themselves and withdraw the request to have the daughter involved, and that worked itself out. But that was an example of another ethical dilemma there with diminished capacity. We don't want to breach confidentiality. We don't want to report abuse if we can't, but maybe we can ask one of the litigants to do it. We can do nothing, we can withdraw, or we can work a way for the parties to decide this question for themselves, and that was eventually what worked. All right, so let's wrap this up today with a summary of what we've been through. Longevity is increasing. Our population is growing everywhere in this country, and we have to pay attention to that as what may be a new issue for us. People are getting up to these ages of 100 plus, and they're still engaged in legal services. Age-related diminished capacity is always a risk, and our cognitively impaired clients are more at risk for abuse, financial abuse in particular, than younger people. Elder abuse is widespread, and we have the possibility of making a difference, taking a preventive role, reporting, calling a third party. We have the option as trusted lawyers. Financial capacity is a very complex area. Please understand that the client needs to have all 9 domains intact to really have capacity. And very important here, expand your consideration of using surrogate decision makers when you can to protect impaired clients. Ethically, we all have choices to make about these transactions and cases involving our aging clients. When you're not sure, let your conscience be your guide. See if you can get a client to agree to allow you to talk to a third party. All right, and just finally, we have some practical tools available for you to learn more about these issues. Our website, agingparents.com and aginginvestor.com, have videos, articles, internet links to some helpful resources, and YouTubes to show yourself or your client. And these things will give you perhaps a deeper understanding of all of these issues and what your clients are facing with their families. For lawyers, we have a book, which is an ABA publication that I've written, which is available to you at aginginvestor.com or shopaba.org. And we delve much more deeply into the capacity issue and address the impairments aging clients often have. It's not like most law books. It's short. I did that on purpose, but perhaps that will help you increase your understanding if you're interested in getting more. And for your clients, for those who have an aging elder, and you may have a lot of clients with aging parents, Their family members need to know how they're supposed to address diminished capacity. And the Family Guide to Aging Parents is a book that we've written for them, and it's also available at agingparents.com and on Amazon. And finally, we've got a book that applies to lawyers, but it was written specifically for financial people, and that's called Succeed with Senior Clients. It's a financial advisor's guide to best practices. We really get into financial abuse in this book, and we get into the 9 domains in more detail with more examples to help you understand how you might apply this. Please feel free to contact us at agingparents.com or aginginvestor.com. Signing off now, I'm Carolyn Rosenblatt.
And I'm Dr. Mikol Davis.
Thank you very much.